us for this important community meeting. We appreciate that it is the weekend, and we recognise that not everyone who wanted to attend today could attend due to our last-minute organising of this event. So we are live streaming this meeting today for those who were unable to make it. I'm Roxy Steele, co-founder of PlaneSense, and I work alongside Louise Picker over here at the table, who is also co-founder of PlaneSense with me. You'll see around the room people wearing PlaneSense t-shirts. These are some of our committee members who help us with our decision making and all the work that goes on behind the scenes. I will be chairing today's meeting, and we will have some time for questions at the end. We are very limited on time today, and we have a lot to get through, but we are here today to talk about the change of flight path that happened on 1 December 2022. PlaneSense does understand the community grievances, and we are feeling it every day as well. When we get to the question time, please focus your questions on what you hear today and where we can go to from here moving forward. Before we get started, I would like to say thank you to Greg O'Connor, our MP for Ohio, who spoke of the work PlaneSense is doing at the recent special debates and local issues in Parliament, and also mentioning it in his community update. Thank you, Greg.
Sure.
I would also like to thank Public Health and the team who have been working with us over the last year, and who also had 4 representatives attend the airport meeting with us on 27th of March. I would also like to thank you all, our community members who are here today, supporting us regularly on our Facebook page, and who are also donating money towards this cause so that we can take action in terms of getting expert advisors and legal advice and everything else that costs money with this work. My slides aren't moving. One moment. Meeting purpose. Alright, so what we are all here about today is to discuss the proposal that Wellington Airport released as a media statement on Wednesday, 10th of April, following our meeting on the 27th of March about the noise report. This is an important step in our community group, and this is progress that we want to acknowledge. It has been a long time working on this to see some position movement from the status quo that we currently have. And this proposed consultation is important for us to discuss today. PlaneSense is driven by making sure our voice is heard at the airport and Airways table, as they did not give us a voice or any notice when they were going to change the way we live our lives in our homes every day when they implemented the DMAX flight path change. Before we get started, I want to thank Councillor Diane Calvert for her support and invite her up to speak. Diane has been supporting PlaneSense throughout the entire process. She has become a bit of a mentor to Louisa and I along the way, helping us work against these large corporates. And she has attended all of our airport and Airways meetings with us and asked some really tough questions on our behalf.
Thank you all. I have made the reason I attend the meetings is just to make sure that the community has a voice with the airport and with Airways. And whilst I'm slightly impacted by the noise, not to the extent that a lot of you are. So I've seen my role as making sure that I enable PlaneSense to have a voice and they get listened to. And I think it's important that I'll just recap on that meeting from my perspective on the 27th of March. And I think the key thing from it was they were not prepared to say, sorry, we got it wrong. Now, they may well have been that way because they're worried about consequences if they say sorry because of litigation, and that's probably what's down to it. But I think it was very telling, even when we had public health there, and the senior public health official said, aren't you listening to the community? Can you not say sorry, we got it wrong? Now, sorry, we got it wrong means 2 things. It means compensation, potentially, or it means also reverting back to the flight maps to where they were. And from my perspective, what I can see is continual delays. And I think this group has been extremely patient, working with Airways and the airport in making sure, okay, well, where will we put the monitors? Can we make sure we get the accurate advice, that we're putting them in the right spot? And that took a while, and then they didn't have enough monitors, so then they had to go and purchase some monitors. And then they had to wait for the results to be analysed properly, and the results showed exactly what you could tell them. So, but then they got the proof now, and now they recognise, and they've couched it with going back to that they need to consult, which is fine, but they need to figure out where they're going to put the monitors again. And I just think, again, it's continual delays. So I'm pleased to be able to call this meeting, and I just want to say to the Plain Sense group, these are all volunteers. They're putting in all their time and effort and their expertise. So I know a lot of you will be very angry with where things have got to through the airport and Airways, but can I ask you not to take it out on the Plain Sense group, because they're doing their utmost best when they're all trying to hold down jobs and look after their families and that. So, all I can say is they've been absolutely professional all the way through. In the meetings I've attended and what the material I've seen, I wouldn't want to go up against them, but yeah, but no, they have done. I couldn't fault what they have done to date. So thank you.
Thank you, Diane. Okay, now I want to share with you the timeline of events. All of this and more information can be found on our website. We've now been living under the flight path that appeared overnight with no notice for nearly 18 months now. We have a growing membership of hundreds of community members who have shared their experiences and support for the work Plain Sense is doing. This is what continues to drive our work, and the fact that we do not sleep much anymore and have changed our habits to manage our well-being. An important date that I want to highlight on here is December 23, which is when Plain Sense became incorporated. This is important as it means that we've put measures in place around how decisions will be made, and we can also act as a group to take action when and if we need to. So I want it to be noted here that the work and effort that Plain Sense Wellington has put in over the last year has been massive, as Diane referred to. Every week we're communicating with community members, expert advisors, we're communicating with Wellington Airport, Airways, CAA, and so much more. It's been felt through the work that we're doing that it is slow and hard, especially when working with Wellington Airport, Airways and CAA. Information that we receive is redacted and incomplete. We're always following up, checking in when they're going to be responding to us, and putting a whole bunch of puzzle pieces together. So I want you, our community, to know that we are working really hard on this still today, and we are still probably facing at least another 18 months of this, no matter what outcome we look to see today. But we'll get into those details a little bit soon. So, the airport proposal. As highlighted in our timeline, Plain Sense met with Wellington Airport and Airways on the 27th of March. This was our first meeting after receiving the noise report. At this meeting, we shared our views on the noise report. So we shared, whilst there were some issues with the report, such as averages still feature heavily, including days and hours where there are no flights. No. There's a lack of comparison of single noise events to ambient noise, where it has been averaged. So it doesn't show that comparison between our otherwise peaceful ambient noise that we have with loud single noise events that take over with planes flying overhead. The lack of this information is particularly noticeable in the 6 to 7 a.m. analysis, when our suburbs are the quietest. The figures in the report are linear and don't represent the increase in sound intensity that is the case of the decibel scale, which increases exponentially. The conclusions are dismissive, so in there 10 to 17% of people being highly annoyed, and that this isn't significant. It is significant in our case. In general, the report supports our concerns. More aircraft do fly over our suburbs than they did previously, with a concentration over our suburbs as a result of DMAPs. Aircraft noise is generally louder from runway 34 than runway 16 to the south. The suburbs are experiencing excessive noise levels up to 80 decibels. Residents are not experiencing the 1 to 2 decibel change in noise, which was in the Marshall Day February 2022 report that was informing the decision that Wellington Airport originally made. Instead, it noted that residents are experiencing a 4 to 5 decibel increase in sound, and again I remind you that's exponential, those decibel ratings. Comparing the Marshall Day Airport that we got through OIA, that the airport based its decision on not to consult with the public before approving DMAPs, and this December 23 report that we've got, the information on which Wellington Airport based its decision was wrong. The email stated expected low levels of noise at 45 and 65 decibel LA max averages, but the report that we got in December records aircraft noise up to 50 decibels to 76 decibels, so a bit of a difference between those two reports, which explains what we're feeling. Comparatively, the Environment Court has confirmed that a 5 decibel increase is significant, and noise experts generally consider a 5 decibel increase to be significant. That was missing in that report. Various Marshall Day experts, including the founder Christopher Day, has confirmed in evidence that the WHO curve is the most appropriate as it represents the latest research in the area. So in the 2018 noise guidelines, it recommended a limit for aircraft noise of 45 decibels. As the research indicates, almost 10% of the population are highly annoyed at this level. At 50 decibels, it's expected 18% of people would be highly annoyed at that level. In that 2018 noise guidelines, it recommends reducing noise from aircraft to 45 decibels. And adverse health effects are associated with aircraft noise above 45 decibels. And this is consistent with what our residents are telling us today. So the Airport and Airways shared with us in that March 27 meeting that they would like to put together a proposal to share with, for us to share with our members. They specified that this would take a day or two and they'd get back to us. And that this proposal would be a genuine consultation on 3 options. These 2 here. Changing the northerly route for jet departures before 7 AM to fly over less populated areas. Reverting to the northerly route for jet departures used prior to December 22, or maintaining the status quo DMAPs that we currently have now. In that meeting, we questioned how genuine this consultation would be if reverting to the northerly route for the jet departures used prior to December 22 has never been an option to date. And even in that meeting, was referring to it as an option that they don't want to consult on. We questioned how the consultation would be fairly assessed and what principles would sit behind decision making, and how a consultation process would be fair when Wellington Airport is not a neutral party. In that meeting, as I mentioned earlier, we were accompanied by representatives from Public Health, with one very experienced and senior representative suggesting that the organisation should apologise to the residents for the wrongdoing, which Diane mentioned. We ended this meeting with an agreement that the airport would share with us in writing what their proposal was, and we would share this with our community at a plain sense only members meeting. We followed up the day after this meeting with an email to share information that they requested from us, and also just to understand when we would receive this information back from them to share with our members. As no dates had been specifically agreed, just that kind of 1 to 2 days. And we were understanding that it was coming up on Easter Friday, everyone's busy. We are understanding and reasonable. But it wasn't until the 8th of April, so over a week later, that we finally received a response saying apologies for the delays, and we'll send you a written summary of the proposals and process from here within the next few days. It was then on the 10th of April, so Wednesday, Louise's phone rang, and luckily she was available to answer it. and she was advised that a public media release would be released from Wellington Airport within the next 30 minutes, and that they'd email this to us. This wasn't our understanding of the agreed next steps, and we would have expected a written response to Plain Sense directly regarding this, considering we're meeting with them and having these conversations. It is to be noted though, we didn't let this stop us. We are here today at short notice to meet with our members and to hold this public meeting to share this proposal and hear from you, our impacted members and community, what action you would like to see taken forward. Unfortunately, the short notice does mean that not everyone could be here today, but we are live streaming. It is Plain Sense understanding from the meeting that a consultation process will, this time, take some planning and time to do so, and it would involve identifying the communities affected. This is not just our community, but all the communities that would be involved. Communities will be notified by mail drop, not just reliant on social media and website communication. Then there would be a consultation process, decision making. If moving to a change, noise monitoring this time would take place before and after. It would at no stage include a collaboration with Plain Sense in what the consultation process would look like, or engage with us to sign off on it. Of note, Wellington Airport said that they would go as fast as possible. However, we note that the sound monitors took 4 months to be installed last time. I think on our timeline that we had up there, it wasn't until late September one of them got installed. From that date of agreement, what have we got here? Just getting on my notes. There is also a cut-off date that Airways has adamantly referred to get things in place for 1 December implementation on any given year. We are less than 7 months from that cut-off date at this point. Therefore, we should be looking at 1 December 2025 date for the change, or even later, if not at all, depending on the decision made. So if we are to go through this proposal that Wellington Airport have put to us. Whilst the airport's media release headline was Wellington Airport asks Airways to develop alternative options for Northern flight paths, Plain Sense specifically asked if there were any alternatives being considered other than the 3 options discussed. Flights before 7 a.m. referring to the previous flight path and status quo. James Evans from Airways specifically said that the alternate flight path they are considering is the 6 to 7 a.m. flight. There are no other alternative flight paths being considered, so something to consider there. It is our concern that the right and fair thing to do would be to revert back to what was and then start a full consultation from the beginning, as should have been done at the time. Wellington Airport's proposal doesn't include any guarantee that peace will be restored to our suburbs, or any time of when. The media release does not reference our neighbouring suburbs, Crofton Downs, Ngaio or Haria Valley. Our community has been suffering the effects of poor procedure and process for more than a year now, and we are concerned for community members' health and wellbeing as time goes on. The consultation, as suggested, has every chance of pitching Wellington communities against one another unnecessarily. Neither community has any responsibility for any wrongdoing in this situation, yet it's everyday Wellingtonians who are paying the price. Quite simply, mistakes were made, and we shouldn't be in this position, nor should residents have a clash as a result. All right. I'm now inviting our legal expert, Kim Murray, up to talk. He has attended our meetings. He spoke at our last one in June that we held last year, and we're very lucky to have him living in our community. Kim is going to share with you his thoughts on the proposal that Wellington Airport has posed and discuss some options that we have. Once Kim has spoken, we will hold a meeting vote to give our Plain Sense committee an understanding of how the community feels and what options we should consider next. Kim, I'll invite you up to speak.
Hello everyone, here I am again at another meeting and Roxy's outlined some of the background of how we've got to this point. I also attended meetings at Wellington Airport with Airways representatives and airport representatives. Just to give you a bit of background about that, Airways turns up with a technical person, a public relations person and a lawyer, and they're very defensive, and they have a very strongly expressed view that they're not going to change DMAPs, and not only that, in the first meeting I attended with them, they said they didn't want to devote resources to considering alternative options, which is somewhat surprising given that Airways Corporation has a statutory obligation under the State-Owned Enterprises Act to take account of the interests of the community. So they never did prior to DMAPs, and as far as I can see, they're not proposing to do so now. And the only reason they're going to be looking at alternatives is because Wellington Airport has decided that's what's going to happen. My concern is that Wellington Airport does not have technical expertise in air traffic control or instrument procedure design. They're entirely dependent on Airways. So we're in a situation now where Airways is still hiding behind the airport when both Airways and the airport have legal obligations to the community, which have been ignored. The significant development really that I can report since last being here is that after extensive OI requests to Airways and their subsidiary Aeropath that designs these procedures, we then started tackling the CAA to see what regulatory approval and consideration had been given to DMAPs. It was like pulling teeth. It took months to get documents, and we haven't got the full story, but it shows that many officials within the CAA were concerned about the safety issues relating to DMAPs. I could not see any document which managed the process properly. It was just emails going all around the place, including back to Airways. It's very hard to see if or how the safety issues were resolved. In any event, Airways went ahead and published the procedures to the airlines to be effective 1 December 2022. But the concern I had with the OI documents obtained from the CAA, that not only was there no evidence of how the safety procedures were resolved, the final step in the regulatory process under the civil aviation rules is that the director must gazette all the instrument procedures. Now, that might seem just like a technical procedural step, but in my view it's actually very substantive because instrument procedures are critical to safety. Aircraft fly in instrument meteorological conditions where the flight crew may have no visibility from shortly after takeoff until during the approach. And so they're entirely dependent on the instrument procedures to keep the aircraft clear of terrain. And that, in my view, is why the civil aviation rules require a final gazette notice from the director. It was only because of plain sense persistence that we discovered that had not been done. And under some pressure of time, the director quickly responded to our letters and emails about that by quickly gazetting these procedures. Now, that means, in my view, the procedures have probably been invalid for 1 year, and the gazetting procedure may be invalid as well, because if the purpose was just to gazette without actually making a substantive decision about the safety issues, then the gazette notice were probably unlawful. So we have this bizarre situation where we have two public bodies in an airport who know of these non-compliances and illegalities and yet are playing hardball with us. Normally, when you get an approach, as we've had now from the airport to consult, I would say, well, that's progress and we should respond positively. But as Roxy has indicated, I have grave concerns about the process. We expected a formal letter that would have been considered probably by their lawyers, and that's what we'd be responding to. Instead of that, we got a media release that offered consultation at the same time is arguing the merits and the justification for DMAPs. So you can see we're set up for a consultation process that is going to be, in my view, on the wrong premise. It has to go back to where it was. before it could be a valid consultation process in accordance with administrative law requirements. So, my recommendation to everybody is that we reject the proposal. We write back and we say that we want the original track reinstated, after which there can be consultation. If these organisations maintain that DMAX is the only procedure for Wellington, fine, reinstate the existing tracks, consult about that, and then it will continue on the process that it should have followed originally, and that we shouldn't be prejudiced by the proposal that's now being put up, which has many concerns which I won't go into at the moment. So that's my recommendation, and I expect the airport will talk with Airways and they'll come back and refuse to do that. In my view, that then adds another decision to judicially review on. And as a litigation lawyer, I'd always be slow to recommend litigation, frankly. It can be long and tedious. So we're facing an unusual situation where the proposal, the consultation proposal, is going to be lengthy with an uncertain outcome, and judicial review will be with some advantage. Now, just to clarify a couple of points, judicial review challenges the legality of what was done. The other type of proceeding is a damages claim for tort, such as trespass, nuisance, negligence, to produce compensation. Now, they're quite different types of procedure, and what I recommend is judicial review first, with the possibility of a compensation claim to follow. Because if you take judicial review and you strip away the legality of what was done, you then have a very solid platform for a claim for tort damages or wrongful harm. And so I'm not saying put that possibility of compensation off the table, but the critical thing is that with judicial review, now that plain sense has been incorporated, it can bring the case. And it's a public body with legal status, or at least a private body with legal status, that can participate in a court proceeding. And judicial review is relatively streamlined. Having said that, there's plenty of bumps along the way. But the question of compensation could be left over, and if any residents particularly harmed feel angry enough that they do want to take claims for compensation, I would say if you were talking to your lawyers about that, carry on talking to them. Plain sense is here to be a resource, and it may come to this point where we could get a litigation funder interested on behalf of all the residents affected as a we have plenty of grounds for judicial review against Airways, Aeropark, the Civil Aviation Authority, and the airport. There were process failures. All of these parties had an obligation to consult the residents. But more substantively, what's happened is they've all designed a procedure where heavy jet aircraft are required to turn left at a lower altitude than they used to, fly over higher terrain than they used to. And this creates a safety concern, not to mention the noise and spraying of toxic fumes over the neighbourhood. It's counterintuitive to do this. Wellington Airport has a geographical noise abatement advantage because aircraft can approach and depart over water. And what has happened is these corporate bodies have compromised the innate noise advantage that Wellington Airport has. And that is objectively unreasonable in administrative law terms, or perverse and in defiance of logic. So I do think that there's a very strong chance that once this case is in court, it will fly, excuse the pun, but it's not a weak case. Now just, I should warn it could be a lengthy process because litigation is like that. You know, you get, each side has an opportunity to do discovery of documents, and there can be interlocutory procedures and so on. But there are ways of speeding things up, and as a litigator, I'm fairly experienced experience in doing that. Now, when it comes to this choice that we should make, do we participate in this consultation or do we commence a judicial review? I just want to mention some advantages of judicial review. First one is that we could possibly apply for an interim order, and the interim order would be at least to require the 3 or 4 early morning flights to depart over the harbour instead of our houses. Now, that we are on common ground now with the airport, those flights, there's no justification for them, and the airport's quite clear about that they have no arrivals before 7 o'clock. So these jets are protecting the airspace for a go-round or missed approach, when there are no aircraft to do that go-round or missed approach.
But Kim, there's also a problem at night, because the noisy Jetstar JQ266 is scheduled to take off at 21:55, and even this week it took off at 10:55, and by the time it got over us, it was 11:02.
Yes.
And it has many times as that Jetstar flight, which is the last flight to take off from Wellington. Not until the internationals come in an hour and a half or so later. There's nobody else, and there's no reason why that Jetstar can't go straight up the harbour.
Exactly, and I heard that, Jet, and it's the same situation at the end of the day. But they haven't talked about that. But what I'm saying is they have acknowledged that there is no reason for these jets to pass over our house in the early morning. If I could look forward to what they're offering, I think after probably the rest of this year and a good part of next year, and the consultation, noise monitoring and so on, they will probably come back and say, yes, we're going to stop those early morning departures and they'll follow the harbour track, but we're going to maintain DMAPs. I think that's where we get to. And that's sort of implicit in the meetings we've had with them and the consultation proposal that we've seen. I just want to mention one point that may not be generally known, and that is that the Johnsonville, Broadmeadows and Kandala are in a noise abatement area. You may find this shocking, but these three suburbs are right underneath this chartered area in Part 93 of the Civil Aviation Rules. And there's a hashed out chart at the back of Part 93 designating the noise abatement area. So you not only have these organisations not consulted with us, they've actually gone and designed a procedure that goes right through the middle of the Minister's noise abatement area. And this was, of all the documents we've seen, the residents' interests were not taken account of, and nor was it noticed that the new design procedure is to go through the noise abatement area. So you can see how bizarre this situation is that we're having to deal with. Anyway, just getting back to the advantages of judicial review. I think the first one is that we could get that interim order. Now, they're quite hard to get because if it involves a cost to the other parties, you're asked to give an undertaking as to damages to pay the cost. But in this particular case, I don't believe there's any cost. So we could apply for the interim order. We might get by consent, given that they've actually agreed it's nonsensical. The second thing is we get full discovery of documents. And at the moment we've been hamstrung because these organisations have released documents slowly, bit by bit, and with redactions. And it's very hard to see actually what happened. You can see it's been shambolic, but you can't actually work out exactly what happened. And some of it, of course, is entirely off screen because there's reference to meetings, but the meetings are not recorded. So as a first step in judicial review, we will get all the DMAPS documents and they'll have a legal obligation to discover everything that's relevant to these issues I'm talking about. The third point is these organisations know of all this illegality and poor procedure, and they're very defensive about it. It hasn't got them to the point where they're going to apologise, but it is distinctly possible that once we file a judicial review proceeding, we will get a capitulation. And if we don't get a capitulation, there's also the possibility of setting up a mediation chief executives would attend with a skilled mediator, and they would find it very difficult to justify what they've done, and that may be a face-saving way out for them. And there is a face-saving issue here, because Airways Corporation does not want to admit to its airline clients or to the airport they've got it wrong. That's what we're dealing with, and it's very hard for them to backtrack. So there are advantages in judicial review. Now, coming to the hard issue, and that is funding. We need, as Plain Sense being the applicant in the judicial review, we need $100,000 in the bank. Now, you say, why is that? Well, there's a number of reasons. One is we've got solicitors downtown ready to act for us, Dalzell, Wellington, and we've kept them up to speed. We haven't paid them anything yet, but they have been willing to read our documents and keep up to speed with where we're at. So they're available, but we can't ask them to write solicitors' letters and deal with these aggressive parties for nothing. They're a law firm, and they have staff to pay and so on. So our first thing is we need to launch the judicial review. We need solicitors. Solicitors then would instruct counsel, and I'm prepared to be instructed on a pro bono basis and act as much as I can to keep the cost down. The more significant reason is that once you file judicial review, all these parties will apply for security for costs. They'll say, oh, you're just a little incorporated society, and if you're wrong and you lose the case, you have to pay us costs, but you don't have any money. So we need to have the money in the bank to be a serious litigant to head off that attempt to stall and prevent the case going ahead. And that's commonly done by corporates, even against public interest bodies. You wouldn't believe it, but it happens. And the judges then have a difficult decision. They usually come up with an amount that secures the costs, but not an excessive amount. So if we've got $100,000 in the bank, that will probably defeat any attempt to stall the case. The third reason why we need the money is actually we'll probably need to fund independent experts. We're dealing with big organisations which have huge revenue, and they will have notified their insurers, and a lot of work will be going on behind the scenes in their areas to prepare, and we'll expect big affidavits explaining the brilliance of DMAPs. So we do need to have at least some technical expertise to draw on as expert witnesses and fund that. Just last but not least, I think it is significant that the Ministry of Health, Public Health Division people turned out in force to Wellington Airport, and they have already engaged an expert consultant, and it is possible that if we commence judicial review, we may be able to get that expert consultant to give some independent evidence about what the acoustic report actually means in terms of not just the measurements of sound and noise, but the effect of that on human beings. And that's a different type of expertise, because those experts are public health experts who know and can give expert evidence about the detrimental effects of noise on human beings, which we all know what we're experiencing, but in court that needs some explanation. So there might be quite a few questions arising out of that, but that's all from me for the moment, and I hope it's sufficiently clear to indicate on a fairly balanced basis what our options are, and that's why, for plain sense, this poll it doesn't mean you're committed to anything, it's just an indication to help Plain Sense Inc. Make a judgment call on which way to go on this. And I just can't help but emphasise it's no good saying, yes, let's judicial review if the money doesn't follow. Yes?
Kim, I remember you speaking at the previous meeting, and you said you were walking the line between your professional career and being a Broadmeadows resident.
Yes.
So how does that sit in terms of having your ability and your expertise?
It's a very difficult situation.
Yeah.
I think the attitude I'm taking at the moment is that I don't have any private information from Airways or CAA, so I think that I can act as counsel. But what I would do is get Dalzell Wellington to write to these parties, say they're proposing to instruct me because it's an access to justice issue, and that I have A, the expertise, and B, the ability to act pro bono as much as possible. They might come back and object, but if the grounds of objection are not professionally sound, I'd likely to say, put up or shut up. So it's an uncomfortable position, but I feel I've seldom seen such a debacle. You know, you don't often see this type of corporate misgovernance and regulatory failure. And when push comes to crunch, A, I live in the area, and B, as a lawyer, my job is to correct this sort of stuff.
Thank you.
Yes.
I'm not sure if this is 100% correct, but as far as I'm aware, Wellington City Council is a 34% shareholder
Correct,
in
yes.
the airport, and my understanding is that as a shareholder, they have an obligation to the citizens in representing their interests in terms of transparency, accountability, ensuring that the airport operates in a manner that benefits the community, includes advocating for fair pricing, safety, environmental, sustainable, and community engagement. And I would like to know what else the council can do to support this process, including potentially whether or not they should be putting in funds to support this initiative.
That's a very good question. I might like to comment, but quite early on, Plain Sense wrote to the mayor, and we got brushed off.
Yeah, so I'd like to know why the council.
Should we just park that for a
Anyway, so that's my
moment?
question.
Because there's more questions popping up, and then we'll try and wrap them up. Yes.
Kim, in sort of analogous situations, the Ombudsman might be wanting to have a look at process failures, procedures failures, and governance failures in public bodies. What's your perspective on the tactical advantages of going to the Ombudsman, of using the Ombudsman in our case?
Waste of time, basically. The Ombudsman's office is swamped with work, and they'll probably reject any approach anyway and say that you have a right of judicial review, and if you have a right of judicial review, the Ombudsman's office doesn't have to or would not exercise jurisdiction. And interestingly, just as an aside, I've just completed 7 years of litigation against the Chief Ombudsman, with 2 trips to the Court of Appeal before my client managed to require him to comply with the law. So these cases are all reported in the law reports, and that gives you an idea of just how difficult, even when you have a very strong case, sometimes you have to litigate in the High Court. If the High Court judge, being a single judge, gets it wrong, you have to go to the Court of Appeal. And just on that issue, you could have a complete win in the High Court, but they could appeal us to the Court of Appeal. And if they lose there, they could appeal us to the Supreme Court. But so be it. That's the nature of litigation. And a fight, sometimes the fight has to be fought. Yes?
Why would the interim order just be limited to the morning flights, given this background of information we provided about things like the abatement area and everything else like that? Why not ask an interim order to go to return things to as they were?
Yes, I would very much like to recommend that, but the response will be we have to give an undertaking as to damages, and that means if we lost the case, if the court made an interim order and we lost the case, the airlines could make a claim against us for all the changed procedures if they could prove that it was a loss. And we can't really afford to put up a security for that type of scenario. So I'm only picking that 6 to 7 a.m. slot just to basically achieve something in the short term while we litigate. And at the moment, we're being offered consultation while the jets are flying over our house. So I just flagged that as a possible issue where we would get an interim order for the 6 to 7 a.m. It's a shot across their bows because it shows, it's an example of why DMAPS is actually not necessary. There's hardly any time during the day there's a jet that needs to do a missed approach. It's not even on approach. So, yes.
We'll take one last question.
Just with the technical failures or non-compliance that you noted, is that listed in there, all of the bits that they've missed legally?
Yes, yes. In response to the airport's public relations media release, we, Plain Sense, put together a very detailed response. So after this meeting, I understand, and that will be released with a general media release, and all the detail will be set out there, so that the media release was just a lot of spin, really. It's a very superficial presentation, and if you want to look behind it and see all the legal work that we've done, and what the true position is, it'll be all set out in about 4 or 5 pages. So just on that note, Roxy, thanks. Perhaps just on the Wellington City Council issue, which I personally found very frustrating, because the council is taking our rates. It has a mayor who sits as a director on the airport board, and it has a conflict of interest, because it has to make a profit for the airport, but it has to represent the interests of us. We are, in effect, shareholders in the airport.
Exactly.
And there's a director on that board that should be challenging the decision-making at council level, and if that was done properly, in my view, DMAPs would not be sustainable, and it would be resolved very quickly without litigation. Unfortunately, we have not made any progress with the council, despite Diane's advocacy, I might say vigorous advocacy on our part, and we're extremely grateful for that. But we're dealing with a whole council and a mayor, and it hasn't been effective yet. And I'm sorry if that puts you on the spot a bit, but whether you want to say
It's
this.
directed to the council, not you.
Yeah, no, look, I understand that, but look, trying to get money, I mean, Ray, Tony and I can't even get $50 from council at the moment to hire a room to talk about the long-term plan. That's what we're facing at the moment. So, but I think there's probably an option now where we really need to make sure that we do meet with the mayor, and also we have one other director, Wayne Eagleson, who is representative of our shares in the airport. So I will try and get us a meeting, because I think we need to brief them on what comes out of this meeting.
Yes.
And we need to, I mean, this is a whole failure of process, and you expect, I don't know whether anybody's been watching Mr. Bates. I'm not saying this is bad, but look, I'm just saying this, you have your trust in public organisations. You expect them to do the right things, and they sometimes don't do it. And so I just think we need to make sure, and Kim's outlined it beautifully, there has been a failure in process, and they need to go back before they start again.
Yeah, good.
And I think that's the key, and we need to try and get to that outcome, because you're having to go to the next stage in litigation or judicial review. You're having to fund to get what should be being done.
I just want to know if the directors are in breach of their obligations as directors.
I can't answer that one, but
What we do know right now is today we are in the strongest position that we have been this whole entire time, and that puts us in a position to move forward. So that takes me nicely onto our next slide, which is Plain Sense Wellington Incorporated. Would like to hear from you, our community, the people who motivate us and keep us doing this work. So please use this QR code up here, or input this little URL into your phone web address. We will have this live right now while we're in the meeting. It's all anonymous voting, but we are really keen to hear from you if you are voting option A or option B. As what Kim said with option B, there is a cost to it. And that is to put up those funds of security. What I want you to know, that as Plain Sense Wellington Incorporated is incorporated, we do have a constitution that governs everything that we do. So all money that Plain Sense raises over and above what we use after payment of our debts, costs and liabilities will be distributed to a not-for-profit body or bodies as approved by a majority vote at a committee meeting. No member has any right, title or interest to the Society's surplus assets or funds. So that is in our constitution, and I want you to know that as our community. that any funds that we do not use will be distributed to another not-for-profit body, which we'd be looking at within our communities. Yes?
May I sorry if my English is not good enough, but I'm just wondering if both options are on the right track at all. When I saw the media release last week, I felt they're playing with us. And they will play with us in the next 3 to 5 years. And with both options, I tell you, at the end, nothing will change. We will sit here in 3 years. We will discuss about noise levels. We will discuss with Airways if rather people of Newlands will have noise or people in Broadmeadows. They are just playing with us with this thing. And I'm honestly, nothing will happen. So what I would like to discuss, or at least think about, to go into a totally other direction, to say to not only to Airways, to say to the airlines, to say to every single Wellington citizen that these people play with lives. It's everybody knows, the most dangerous parts of every flight is landing and starting, and they fly over a residential area where they are not needed to. They can all fly over the ocean, and there's no other direction. And I think that's the only thing we should demand. We could get every single Wellington citizen on that track. We could go to the mayor and tell the mayor, why do you spend millions of ratepayers' money to make some buildings earthquake-proof, which happens every 100 years, but you don't care about security and safety of people living under the paths. I believe this is the only option to get public support and to go forward. And all these options, it's nice, I appreciate all the work, but I'm not seeing any success with it.
Just comment on that. I mean, these issues exercise our mind, I can assure you. We have all options on the table all the time. Just to indicate that we have actually written to the Transport and Infrastructure Committee of Parliament, and they're conducting the annual performance review of the Airways Corporation as an SOE and the Civil Aviation Authority as a Crown entity. And we have documented it all, including the concern recently discovered about safety issues. I can tell you, and I've briefed the Ministry of Transport officials, so the ministers are not taken by surprise. But I can tell you, in the New Zealand system, we don't have ministerial inquiries until an accident has occurred. That's the reality. You just have to look at Whakaari White Island, Cave Creek, Mount Erebus. All these things, risks are known beforehand, but until something disastrous happens, you do not get either the public engagement or the political engagement. However, having said that, and having put all these things in the system, I'm always optimistic that at a certain point the system will crack. And I do think that the ministers will be considering the possibility of a ministerial inquiry, but we may have to commence judicial review anyway. I hope that.
I mean, I can see that, but it's a question where's the focus on? I'm not saying that this is not good. It's only questioning what's the focus on. And I think if I think about $100,000, where is it spent? And do we spend it on getting public awareness, publishing images in the media, how it looks like if a plane crashes into an apartment, as it happened in Amsterdam and other places in the last years? I think at the end we might get more pressure on the director of Wellington Airport to get the changes than all this legal and noise detection and consultation and all of that, because that will go on for years without any change. And I think there's a higher chance to get a change, to focus and spend money and energy on getting public awareness on the safety issue, not on the noise issue, on the safety issue.
Thank you. It's really insightful and something that we will keep considering and working on. Right now, our focus is on DMAT, but there is a broader case that we need to be aware of.
Well, and this, what was just talked about, the security in it, is actually part of DMAT's track sets, putting it aside as well, because trying to get it back over water, we're all talking about the safety for live under the current tracks. So maybe extra highlighting during judicial sort.
We're not the only community group up against Wellington Airport. There is also one out in the suburbs near Wellington Airport that has been challenging them around extending the runway. There is lots of work going on in this space. We have an airport in the middle of our city. It impacts all of our residents. Today we are here to talk about DMAPs and how it impacts our suburbs right now. And I can see here on my screen that my links did work, which is really good. Oh, sorry, yes?
Yeah, just a quick question. So are the two options kind of mutually exclusive in the sense that if we went for a judicial review, then the airport would not do the consultation that's proposed? Is that right?
The airport can do their consultation still, but what we're voting on is whether or not we as a community are prepared to put up 100k for us to do a judicial review. We can't make a judicial review happen without funds in the bank. So I guess this today is the opportunity for plain sense to have an indication on where our community is sitting, what you were thinking that you want to help inform us to make our decision, but also we're looking at our bank account to make sure that we can do what our community wants us to do. Yes?
Just a question about the cost for a judicial review. Does that money need to go to a lawyer to take it to court, or is that the charge of actually from the court? So if we get, say, a lawyer to do work, perhaps pro bono for us, what would the cost be?
So part of that cost is, as Kim mentioned, is security. So the judge will ask us for security of damages costs.
Oh, I see.
Yeah. So that is a large amount of showing in our bank account that we can cover any damage costs. Yes.
Question for Kim, based on the judicial review. If we launch one, what do you think the chances that CAA and Airways and the airport, maybe even the council, actually coming to the party saying, like, oh, actually, that's not something that we want to happen. Let's go directly into litigation. Is that a realistic?
Yeah, I think it's very realistic.
So basically, threatening them with this could bring them a little bit quicker to the table?
I think we'd have to file the proceedings. It then moves into a different level. Then the lawyers communicate with each other. The risks of litigation are exposed, and you find it's a very sharp process. And in this particular scenario, my understanding is that all the other parties will have lawyers engaged. They've been speaking to each other, we believe, to actually address the legal issues we have identified. And I think once we commence judicial review and isolate those in the pleadings, in the statement of claim, you move into a very sharp arena. All this public relations stuff gets pushed to one side. The legal process is incredibly rigid, and the issues are defined, and things boil down to the basics pretty quickly. So I do think judicial review, it doesn't rule out, you can do lots of other things too. And the judicial review actually is a platform for media publicity about safety, because the judicial review will raise safety issues. So it will
be part of it.
You'll be part of it.
Yeah. Maybe we just take one more question.
It was just basically about, I was interested in what you had to say about your feelings that this is going to drag on, and with that post-office saga, 20 years it dragged on. I just feel, at the moment, I'm not sure how representative we are of all the people that are affected by this that may contribute to this. I know you did a drop with a flyer, and I feel that never really works. Maybe a public protest at the council or at the airport will start to serve to make people aware that there is concern about this, that you're not the only one. There's a whole lot of other people out there that are feeling this. And that might help with the $100,000 raising, because at the moment, falling on 100 people, that might be $1,000 each. That's a significant amount of money for someone. So, I think we've really got to start generating some interest out there amongst the public. And that's not going to happen with a mail drop. It's going to happen by presence on the mall and presence in Kandala, where we're actually telling the public about our concerns, and they can be part of it. I don't think Plain Sense has done that.
No, we haven't done that yet. We haven't been in a position to do that yet. But as I said before, we are in our strongest position today. We are in a position where we have an option of knowing what way we want to move forward. We're in the first time in a position of understanding what Wellington Airport and Airways have got on offer. So if there is a time to do that, now is the time. We do want to fundraise now. We do have a plan to continue more meetings, continue more public awareness around this. We didn't expect the $100,000 to be in the room today. If it was, let's get started. But if it isn't, we will continue to work. Looking at the vote, 95.6% of votes have voted towards option B. This tells me that we've got work to do. We've got fundraising to do. We want to pull this money together. We want to take action. We want to hold these organisations to account. I'm going to wrap it up there. Thank you very much.
Just make a comment on that last question.
Yeah.
My name's Frank Neal. I'm here covering this for the Independent Herald, and I'd just like to react to that last point that was made. Think seriously about writing letters to the editors of the Post and the Independent Herald.
Thank you. Thank you everyone for attending today. Feel free to stick around for the next 20 minutes or so and talk with your community peers who are experiencing what you are experiencing, or feel free to talk to a Plain Centre member if you have any further questions. You will hear from us, and we do have a media release that we are going to put out shortly. Thank you.